Court is now in session.
I am aware that here in VRChat, there's a lot of misunderstandings about motions, what they are, who makes them, and what they're for. So I did hear, I think it was Judge Mia Princess was on the bench, and at the end of the case, she said something like, I move that the defendant is guilty, or I move that the defendant is not guilty. And when I heard that, it just made my hair stand on end, like nails on a chalkboard, like, no, judges don't do that. Judges do not make motions because the authority of a judge comes in and they make orders. And this is something that I talk about with my Chinese law students a lot. They have problems with a part of language called modal verbs. And it's common for them to say, if they say they're representing the plaintiff, they might write, the defendant shall pay me money. And that gives me that same nails on chalkboard feeling because it undermines the authority of the judge. So the judge says the word shall, the lawyer says the word should. And it's a reinforcing of the judge's authority to do it that way. When a king would say it shall be done or let it be done of such and such, that they are speaking with authority. Lawyers do not have authority in the sense that we don't tell anybody what to do. And I remember I was at one point standing in a courtroom representing a client, and the client who was facing criminal charges and had some mental health issues began to stir in such a way that the judge began to be pretty concerned, or I think maybe he was refusing to stand or something like that, as he'd been told to or something. And this judge said to me, Mr. Pure, would you please, can you do something? And I was very happy that I got to look back at the judge and say, I don't tell people what to do. And, the downside of being a lawyer is you don't tell people what to do. You don't actually have a lot of real authority. The only thing that a lawyer can really do by themselves is subpoena somebody, and even that they don't really do themselves. They do through the clerk of the court operating with the authority of the judge. The lawyer doesn't have the power to make anybody do anything. What a lawyer can do, what a lawyer does for a living, is to ask the judge to do something. And the judge, of course, doesn't do anything themselves either. They give orders, and those orders are generally enforceable by the police. Now, as I talk about what is a motion, you would not say that a case is a motion. A motion is something that happens internal to a case. So if I say that a case begins with an initiating document, a civil case begins with a petition, a complaint, something like that, or a criminal case begins with an indictment, an information, a complaint, then that represents the left side of the parentheses of the whole case. And when you start your case, you go and you pay your fee to the clerk to begin the case, if it's a civil case. If you're the government or you're proceeding informal pauperis as a poor person, then you may not have to pay the fine, may not have to pay the fee. But you pay this fee, and what it buys you is a folder. And the clerk takes that folder and will stick in your initiating document. And think of that folder as the left side bracket and the right side bracket of a set of parentheses. And so the front of the folder on the left side, that's where the clerk will stick your initiating document. And on the back end of the folder, and I'm oversimplifying, it doesn't work this way literally. Sometimes it does, but it doesn't necessarily work this way literally. On the back end of the folder, that's where the clerk will stick the final order. The motions are what happens in between. The motions are the small matters which together lay the groundwork for the final structure of the case. And generally speaking, there will be a division made between pretrial motions and trial motions. And then every once in a while, there will be post-trial motions, but we're not going to get into that. And we're also not going to get deep into the idea of pretrial motions. The reason why we're not going to get deep into the pretrial motions is that pretrial motions are not really of much use to VRChat players, because in VRChat we don't have pretrial on the whole. Cine has been talking about getting mock trial set back up, and I want to take this opportunity to ask everybody here, if you are interested in mock trial, I would be perfectly happy to run that as a judge. The problem is that we need people to do the pretrial. And pretrial in mock trial is real work. Last time I did one, I found myself, Reggie and I found ourselves working, I probably put 80 hours into the pretrial. So it does take a lot of effort to put together these pretrials. But the way we do it in VRChat most of the time is we just show up and then somebody makes up the case and they deal with it right there, right in the middle of trial. And you can have motions made in trial as well. Now, although there are some motions which must be made in writing, generally motions can be made in writing or orally. And a trial motion will almost always be made orally. There might be a time when there can be briefing. So if a motion is made orally and a judge says, well, that's an interesting request, I don't know what the law is about whether or not I should grant that request, let's hear some briefing on it. Then the judge will reset the case and say, let's come back in 3 weeks, something like that. And next week, I want the movant to give me their part, and let's have a response for that the following week, and they'll work it out and figure that out. This is one reason why courtroom work can take so long. It's one reason why the judiciary moves so slowly, is that you never really know when the other side is going to make a motion, and it is within the discretion of the judge to decide how much time to give any particular motion. A judge, if you make a motion, could simply say denied right there, or a judge could open it up for briefing and come back. And I notice a lot of geographical differences. I've been a lawyer in Texas and California, and it seems to me that Texas is a place where the judges cut corners. And I think that basically it comes down to money. In a jurisdiction which has very little money to spend on its court system, judges will cut corners. You'll make a motion, and the judge will think they know what the law is, and they'll just say denied. Or, well, usually just denied. But sometimes, whatever. And so that it all just moves at a really fast pace, and they do make a lot of mistakes that way. By contrast, the opposite of Texas, in my experience in the United States, is California. California is a place where the judges are just totally happy to have everything take for fucking ever. I mean, take, for example, the O.J. Simpson trial. There is absolutely no way that O.J. Simpson or anybody else would have been given a criminal trial which from commencement to completion lasted longer than a year. I mean, a judge would hang a lawyer for trying to take that long. Trials take 2 or 3 days, a week at most, in the state of Texas. And that's not because it's written down that that's how they have to be. It's because the judge has discretion to figure out how it is. And the culture of Texas is a place where trials happen quickly, and the culture of California is a place where trials happen very, very slowly. Why that is, there are cultural reasons, but I think mostly it comes down to the fact that California just has more money to spend on its court system than does Texas. And when lawyers sense that there's a lot of money to be made in a case, they will create work for each other. So one side will say, I will write, a 10-page motion. Now the other side has to write a 20-page response. Now you write a 30-page reply, and you're charging by the hour for this whole thing, and both lawyers are getting rich. This seems to be the way that things work in the upper, in the upper reaches of law firms. There's a book, I think by Charles Dickens, called Bleak House, which concerns the birth of a certain legal doctrine called the rule against perpetuities. I am not going to tell you what the rule against perpetuities is in detail. You would die of boredom. But basically it had to do with the idea that if you set up certain kinds of interests in property that are designed to take a long, long time before you figure out who owns them, that those are not valid. But what had happened was somebody had set up more or less a trust, which would have money generated on interest. And if you know the story of the man who, having done a favor for a Chinese emperor, said, take a chessboard. On the first square of the chessboard, put a grain of rice. On the second square, put 2 grains of rice. Then double it again for the third, put 4. And then double it again, put 8. And fill the whole 64-square board that way. And the emperor said, sure, and then was utterly embarrassed because the man had thus, gotten more rice than existed. It was that kind of a thing, that, through compound interest, the amount of money by just letting this thing sit there for about 100 years ended up having more money in it than the entire British economy put together. And the actual payment of that would have been impossible, leading to a massive legal dispute. And so they ended up fighting about this for all those years. But at the end of the book, there's no money left because it wasn't any good. But, you do then know who gets to keep the money. But there was no money left at the end of it because the lawyers had taken it all. And that's the sense of blood in the water or the shark's circle. They just tear it to pieces. But I digress. So within a given case, you can start making motions. And the basic rule of a motion is that the other side must be present. That is to say, a lawyer will ask a judge to do something, which is to say to make an order. And then the other side must hear this and must be given a reasonable amount of time to respond to it. Generally speaking, in most courts, a lawyer, if the motion is made in writing, you must send a copy of it to the other side. So when this goes in writing, it'll go like this. If I want to file a motion in a case, which I would do all the time as a lawyer, the first thing that I'm going to do is I'm to write my motion, and then I'm going to add on a blank page or a page called a certificate of service. And it says, I have sent a copy of this motion to so-and-so, so-and-so being the lawyer for the other side, on such and such day, at such and in such and such way, by mail, by fax, whatever. And usually I would go by fax. I think that now they have e-filing systems that kind of set this up. But you would send them, you write, I have sent this to this person, and then you send that immediately off to the other side. And as soon as you send off to the other side, you go immediately down to the clerk's office. Pardon me, I'm gray screening here a little bit, see what's going on. Okay, that was an issue. Okay, that's an ongoing issue. I think somebody's gray screening me. See if we had anybody else come in. I don't know what that's about. Okay, anyway. Okay, that was something. Okay, what? So, first thing you'll do is you'll send a copy of the motion to your opposing counsel. And the next thing you'll do is you go to the clerk, and once you've sent the motion to your opposing counsel, you take that certificate of service and you sign it, thus having established that you are representing to the court that I did indeed give this to the other side. Then you go down to the clerk of the court and you give them a copy of it. But when you do that, you've got 3 copies of it, and you get them to stamp the other 2. You give one, and they stamp the other 2. Then you take that and you send that. I mean, there are other ways of doing this, but this is how I would do it. I would take that and then send that off again to opposing counsel so that opposing counsel would know that the clerk had received it And when you would see that, you would then go to the court coordinator, right? So you give that to the clerk, they stamp it, and then you put another thing on it called a notice of hearing. And you go see the clerk or the court coordinator, and you work out the day that you want to talk about this motion. And you agree to a date, and you take that. Now you've got a copy filed, stamped, with a certificate of service on it, and with the date and place and time that you're going to have an argument about it. And then you send that off to the other side again. And then that being done, you save the copy of you sending it. So however you send it, you make sure that you can demonstrate later on that you did indeed send that with the notice. And you may want to even file that again with the clerk so that later on, if the person doesn't show up, you can say, well, it's right there. They knew exactly where it was. You can see, this is where it was going to be. And the stamp is on it that the court accepted it. And this is the proof. And generally, when you would do this by mail, you would do this by mail, return receipt requested, and they give you a little you put a little green stamp on the outside of your envelope, and then they, when it gets delivered, it's delivered by hand to the particular person, and then the post person tears that thing off, mails it back to you, so that now you've got that, and you may even file a copy of that, so that if they don't show up, then all the paper trail is right there to prove that you have done everything to make sure that they know when they're supposed to be, where they're supposed to be there. But that's the issue of motion service. You can make it in court orally, and if you're actually in court at the time, then generally the judge will ask the other side if they have an objection, or you may go ahead and say, I object to that motion. If you say you have no objection, then the judge may just grant the motion there, although they don't have to. And we'll figure that out. So, as I said, what can you make a motion about? Well, you can make a motion about anything that a judge may do. Well, what may a judge do? A judge may do damn near anything. I mean, there are restrictions to what a judge can do. They cannot go beyond their own jurisdiction. They can't do anything that's blatantly unconstitutional, etc. Although even if they do those things, even if they go beyond their own jurisdiction, even if they do something which is unconstitutional, all you can do about it is appeal. So that means that, in effect, at the moment, that judge can do just about anything. And so that makes it very difficult to figure out what it is that a lawyer can do. And before we were getting started, I told a story about how I was once standing in a library, and there was this old lawyer, looked like he'd been in practice about 30 years. He was in his 60s. And the old lawyer was really frustrated with the law librarian, saying, I just cannot find the motion for this particular thing in the library. And I went up and said, well, let's have a look at it. I said, we can't. I helped him a little bit, and we determined I couldn't find it either. And I said, all right, I guess it's not here. No problem. We'll just make one. And I got out my computer, and I, filled in some of the stuff and wrote him a short motion right there in front of it. And pulled out my portable printer, because I was always doing that. I always carried a portable printer and a laptop everywhere I went. And the reason why I carried a portable printer everywhere I went was that I might need to make a written motion. If I needed to make a written motion, I didn't want to have to wait around and say, well, I'll get that filed in a few days. No, I wanted to be able to immediately get that filed, because motions tend to be, when you need them, you really need them right goddamn now. So I pulled out my portable printer and wrote this guy up a motion and printed it off for him and said, don't worry about it. You owe me a favor, whatever. And he just had this look like, oh my God, like he was in the presence of a child prodigy or something, because he had never, he told me, in 30 years or so practicing lawyer, never had he actually drafted his own motion that wasn't found in a form book. And I didn't think that made me brilliant. I thought it made him stupid. Because that's what a lawyer does. The idea of the form. I've talked about this a little bit before we were getting started, but the idea of a form is something that is, you make 100 copies of something and they have blanks on it, and you go in and fill them out. And you don't have to be a lawyer to fill out a form. Probably everybody in this room has filled out forms at some point in their life. It's just part of life. But what's special about what lawyers do is that we will, if we find that there's something that needs to be done, something that a judge has the power to do, and there's no form for it, we can make our own form. We don't just go to the spell book and choose a spell. We can build and grow and create our own spells. And therefore, for me to give you a comprehensive list of every kind of motion that a lawyer could file would be impossible, because you could make a motion for anything. You could make a motion that your client be permitted to wear a clown nose in court. You might not have it granted, but who knows? It might be the one case where the presence of a clown nose, maybe it's a criminal case and you say your person didn't do it, and you're sure that if the jury could see your client wearing a clown nose, they would know that they were not, in fact, this particular bank robber who wore a clown nose, and because they look nothing like them even with the clown nose. I don't know. For any situation you can come up with, there's some kind of emotion which is vitally important that no one has ever heard of before. But nevertheless, there are some general motions which are commonly made, and I'm going to be talking about the trial motions because the pretrial motions are not going to be a lot of value to VRChat role players. So let's get started with some of the basics. The first motion that you would most commonly find filed in a trial case, something that's filed in probably just about every criminal case and probably most civil ones, is called a motion in limine. I-N space L-I-M-I-N-E. Generally, motions in limine will be made in writing. You'll generally want to get those filed about 3 days before trial. And then on the morning of trial, the judge will go through the motions in limine. Okay, so what is a motion in limine? If you had any of my classes on evidence, on objections, then you know that there's all these different objections you can make in the event that evidence is being brought in that you think is illegal. Well, the trouble with that is that if you're in a jury trial, and motions in limine are for jury trials, they're not for bench trials. If you're in a jury trial, then you might be concerned about your ability to get the timing right on the objection. Or it might be that just the merest mention of a question, because a proper objection comes after the question, before the answer. And you've got to be quick on the draw. I mean, I was told, when I went to visit North Dakota by somebody there that it's not uncommon, and actually I had a college history professor who used this same phrase. It's trial lawyers are often called gunslingers, because it has that quality of having to be excellent with both timing and accuracy, and mostly that's in the case of objections, because you've got to, you have to be exactly after the question, but exactly before the answer. You have to be quick with that objection, and you have to be able to aim it properly. You have to know exactly what about that answer is illegal and exactly how to do it. So the image of the gunslinger comes up, and I've been called a gunslinger because I object like crazy, and that's how I do it. So the motion in limine is designed to give you a little bit more time, and it may be that you don't want the jury to hear the question. If you're in a criminal case, you don't want the prosecuting attorney to ask questions like, the defendant, why didn't the defendant come to help? Or, you don't even want the jury to hear that question, something like that. In that case, a motion in limine is your best bet. A motion in limine is a motion for an order that the other side should approach before doing certain things, okay? That they should approach before doing certain things. And generally speaking, if a judge grants a motion in limine, they probably feel that whatever that thing is illegal, that they probably shouldn't be doing it at all. Now, if that's the case, why don't you just have a motion where they say, don't do this thing. And this is something that the definition of a motion in limine that I've given you, judges in Texas seem to take the view, I think a motion in limine is what I've told you, that it is a motion that the other party should be required to approach the judge. And by approach, I mean say, may I approach, stand up, talk to the judge at a whisper so that the jury cannot hear before they do whatever it is they do, before they ask whatever question, before they make whatever comment. However, it's perfectly common for lawyers in California to just make motions in limine where they just say, judge, just tell the other side not to do this. Just tell the other side not to do that. And I really think that that's a misuse of the phrase motion in limine, and I really think that that's a misused motion, because I don't think that it is appropriate for a judge to tell a party, don't do X, Y, Z in trial, because the judge cannot possibly know what is going to happen in trial. I mean, few things in a courtroom are illegal in every case. Most things are illegal under the particular circumstances of this case. Well, how can the judge possibly know the particular circumstances of this case if the judge hasn't seen the trial? Because you may think you know exactly how that trial is going to go, but as soon as the trial comes around, somebody changes their story. One of your witnesses dies. Weird shit happens at trial. And I therefore feel like all you can really do with a motion in limine is require the other side to come up and ask the judge, may I please do this before you do it. I think there's a lot of misunderstandings about that in San Francisco. And there's a lot of things in the law, and I think probably every lawyer would agree that there are things that are very basic points of law that the judges don't have a clue about. Well, of course, law is only what courts will do. And if the judge doesn't have a clue about it, well, then that kind of is the law at that point, isn't it? But the idea of the motion in limine is, before you do this thing, go up and ask the judge. That way you can keep certain pieces of information out. And these are commonly used by lawyers in order to pre-try the legal issues in the case. Because generally speaking, if there's a certain thing that you think the other side should not be doing, that you think they might do, you can make that motion in limine, and you can then hear, in some cases, the judge's reasoning about the law. And therefore, you will know in advance what the judge thinks the law is and is not pertaining to the evidence that's relevant in your particular case. And so once you know that, you can then, when the actual trial is happening and the jury is present and, you're in the moment of chaos where you can't take your eyes off the ball, you will at that point know how you think the judge is going to respond in advance. So motions in limine have the practical purpose of telling the other side to approach before they before they do certain things. But generally speaking, the tactical reason of a motion in limine is to get a sense of the law on the issues in your case as the judge sees it. All right, another example of a motion, and by the way, I'm just going to go down, I'm not going down any particular list. These are just the motions that come to mind, because as I said, there is no list of motions. There's an infinite number of these things. But I'm talking about some of the common things that you would see as trial motions. Then there's the idea of the motion to strike, although I think it would be much more accurate to call it a motion to disregard. And this is another thing that I have seen come up in VRChat as an issue. When I was first coming into the scene, Judge Nathan was on the bench, and there was this young woman who was playing a cop. And within 30 seconds, I had won the case just by getting in this cop's head. You remember that, Nathan? Where I had sort of gotten into a confrontation with this person until she just into some kind of, I don't know, semi-racist rant right there in the middle of it. And
I probably remember.
Then, you what? You do or don't remember that?
I probably remember. I can't remember at the moment.
Yeah, that's fine. So that, and then, the other side, I don't know, Judge Nathan or Judge Abe or whoever, said something like, okay, we're striking that witness's testimony, and since that witness's testimony was all there was, I'd won the case. Well, I didn't complain about that at the time because it did mean I had won the case, but that's not really proper. I think that gets overused a lot in VRChat, to strike testimony of a witness on the basis that the judge decides that that witness cannot be believed. That's not how it works, because we would say that that invades the province of the jury. In other words, we have a system in a court to decide who is telling the truth and who is lying. It's called a jury. And even if the judge is performing the role of the jury, which they sometimes do, it still is not appropriate for the judge to say, I'm going to refuse to take any evidence about that. Instead, what they would do is, if there's a jury, and actually, judges will sometimes grant a motion to strike, but just out of, that doesn't mean they actually strike it. They may say, the judge may say, that so-and-so's statement about X, Y, Z, and they, generally wouldn't strike a whole witness's testimony. But say somebody says something they're not supposed to say, like, for example, the prosecuting attorney stands up and says, in closing argument, the defendant didn't testify in this case, and that means that they did it. A big no-no. Big no-no. They must never, never do this. All right, so that's an unambiguous case of something they're not supposed to. All right, in that case, generally what you should be going for a mistrial in that case. I'm getting ahead of myself. But let's say that somebody decides to make a motion to strike. Well, in that case, the court will say, I am striking the person's testimony. And later on, you'll go back and you'll read that record, and it'll say, plain as day, exactly what they said, and then it'll say, the judge says, I am striking that. And it will never actually be stricken, right? Judges don't actually strike things from the record. That would be crazy, because the record is there to be the complete record of everything that happened in court. If you could strike stuff from the record, then what would happen is that judges would learn or allow information to suggest, let's say in a criminal case, that the defendant is guilty, although that evidence is completely illegal, and then they would strike it. So that when the case got to appeal, the appeals judge would just, you would say the judge did this thing, they did that thing, and the appeals judge would look at the record and say, doesn't seem here that they did, I guess you lose. That would be outrageously unfair for everybody involved, and the law is an ass, but it's not that much of an ass. So a motion to strike is not a real thing on the whole. What is real is a motion to disregard. So that is to say, you can ask the judge to tell the jury to pretend that they did not hear the thing that they were not supposed to hear. That's called a motion to disregard. And generally, that is something that would happen if you get the timing just a little bit wrong on an objection, or even if you get the timing right on an objection, but the content of the thing you're objecting to is so outrageous that the saying goes, you can't unring the bell. In other words, some shit, when the jury hears it, they're not going to forget it. Right? But in the case of an objection, because I have talked about objections before, say you make an objection, and the judge says, grant it. You have thus not preserved error, right? The point of making an objection is to preserve error. Because if somebody does something illegal, 99 times out of 100, unless the other lawyer says objection, then when that case gets to an appeals court, the appeals court is not going to care. They might say, oh, yeah, sounds like that person did something illegal. Shame nobody objected. Well, that's the end of it. Because the appeals court feels like if it were a problem, the other side would have objected. And the appeals court also feels like that if they didn't find lots of ways to throw out cases without checking the merits, they would never go home at night. Because no case ever produces a situation when everybody is completely happy with the outcome if a judge makes the decision. So the record has got to be preserved. And so you say objection so that on appeal, if the judge says overruled, meaning your objection fails, then at that point you have preserved error for appeal. That's so, a lawyer who does not want to piss off the judge, and it does piss off the judge anyway, will sometimes say, for the record, objection. That's a little bit like saying with all due respect. You know how when you say with all due respect to somebody, what you're really saying is you're not worthy of respect, fuck you. Well, when you say for the record, what you're really saying is, Judge, I know you are going to say overruled, but appeals will overturn you on appeal. So just for the record, I object. So you may object, and if the judge says overruled, then okay, you lost that issue, but you have sustained an appeal. Well, let's say that the judge says sustained, meaning your objection passes. All right, good job. But now you still think that you should have the right to have that issue heard on appeal, because just the fact that the other side said the thing that asked the question may have polluted the mind of the jury or may have, done something. So in that case, you say objection sustained, move to strike or move to disregard. And then at that point, the judge may say denied. If the judge says denied, you have preserved error, not on the whole issue, but on the question of whether or not the jury should have been instructed to disregard. But let's say the judge says granted. If the judge says granted, the next thing that's going to happen is that the judge is going to turn to the jury, and the judge is going to say, ladies and gentlemen of the jury, please disregard what so-and-so just said. Now, that might not work, because the jury, isn't actually going to do that. They're not actually going to go and perform brain surgery on themselves to remove that information from their own skull. So, in some cases, the thing is so serious that in order to really preserve error, you have to move for mistrial. And the things go in a 1-2-3. It's a 1-2-3 combo. Objection, move to disregard, move for mistrial. Okay? And your motion for mistrial is where you say, Judge, this situation is so fucked. What the other side just did is so outrageous that even if you tell the jury to pretend that they did not hear what they just did, the jury will still not do it. We have to tell the jury to go home and start all over. And the classic case for when you're going to get this is when the prosecuting attorney in a criminal case says in front of the jury at closing arguments, ladies and gentlemen of the jury, the defendant did not testify, and you know what that means. It means they're guilty. Okay? If the prosecuting attorney does that, you should get a mistrial like anything, like picking up a can on the side of the road. Although I am aware of some cases where it doesn't happen, and I say you should, but the law is crazy and weird shit happens. But it's definitely my sense of the law that if they get anywhere near suggesting a defendant is guilty because they did not testify, you should get an instant mistrial on that. So that's the idea of the motion to dismiss, or no, that's the idea of the motion to disregard and the motion for mistrial. Okay, let's see if I can think of some others. Well, you might have a motion for an expert witness as a defense attorney. I did quite a lot of these. These are special in that they can be performed ex parte. EX space PARTE. And really, I think it's the E on the end of parte has a little French accent aigu on it. The ex parte motion for expert, there are a few motions which it is legal to have heard by the judge without telling the other side about it. I know I already said at the beginning that when you make a motion, it's important the other side be there. That is true for 99.9999% of them. But there are a few motions out there which you can make to the judge without the other side knowing about it. And for the defense attorney, the main one of these is the motion for money. That is, judge, give me some money. So that they don't literally give you a suitcase full of money. They give you a budget. And then the people who you hire can then send a bill to the judge. But there is, if you need an expert witness as a defense attorney, let's say a court-appointed defense attorney, you don't have money for the purpose because you are just working on the government's dime anyway. So you may need an expert witness, or you may need a private investigator. You may need to hire a private investigator. So you could then go ahead and go see the judge in private. And you would file a motion, but you would have it sealed because the other side, the prosecution in a criminal case, does not have the right to know who it is you are hiring until trial. So if it's something like that, you might be permitted to see the judge ex parte. But generally, that's not going to be allowed. Let's see if I can think of any other motions. Well, let's move on. And at the end of the prosecution's case in chief, or at the end of the plaintiff's case in chief, this works for both civil and criminal cases, you might move for something that, where I come from, Texas, is called a motion for directed verdict. This is something that defense lawyers do. And the motion for directed verdict says this, that the prosecuting attorney has, or the plaintiff's attorney has, in this case, not put on a shred of evidence about a particular point. And therefore, it would be completely unfair to let the jury make up their mind. Because if you let the jury make up their mind, they might do something called reverse nullify. When a jury nullifies, that's for the jury to simply take a person who, in a criminal case, to say this person is guilty as sin, but we like them because we like, we think that the law they're charged under shouldn't be the law. Or we think that, he's a good old boy and he's got the same skin color as me or whatever. Reverse nullification is the opposite. That's where you have people who, it's where the jury must say, he's not guilty, but we're going to find him guilty because we don't like him, because he's a dirty motherfucker, and because he's got a different skin color, whatever. All right, well, juries generally should not be given a position where they can engage in nullification. And Reggie often walks around with a little banner which says ever jury nullification. And that's a little joke that he puts out there because it is against the law for a lawyer to talk to a witness about jury selection, or about jury nullification, because a jury is not to be told that the jury has the power, which they do have, to just say guilty or to do something other than what the law says. It's not that the law wants juries to have that power. It's that there's no way to stop the jury from having that power, because it's very clearly written in the rules that what a jury decides cannot be revisited. Because if it were not that way, we would be coming up with these cases all day, every day, and nothing would ever get finished. So therefore, the rule is you're not supposed to tell a juror about jury nullification. However, it's the 21st century, and anybody can learn anything all the time, and it's perfectly all right to go around telling someone who's not a juror about jury nullification. And there's been all kinds of interesting legal battles of people who've gotten in trouble standing outside courthouses, handing out little pamphlets describing what jury nullification is. Anyway, it should not be the case under the law that a jury should be in a position where they can reverse nullify. Well, that means that if there is a certain piece of evidence or a certain case for which there is no evidence put on at all, then the judge should simply say, I hereby instruct the jury to find the defendant not guilty. And in that case, there's not even a formality, really. The judge doesn't even send them back there and tell them to find the jury. They just say, I hereby issue a directed verdict. That is what's called a dispositive motion. Motions can be divided into dispositive and non-dispositive. A dispositive motion is a motion that disposes of the case. A dispositive motion is a motion which, if you win it, congratulations, you won the case. Okay? And the same motion, the same kind of motion, can be dispositive in one case but not dispositive in another. And that brings me to another defense motion, and I'm talking here mostly about the defense motions because that's mostly what I know. I'm an old defense attorney. The motion to suppress and the motion to exclude. Now, this is not a class on suppression and exclusion. I could teach several classes on suppression and exclusion. In many cases, when I'm teaching at my law school, I do. This is a whole subject. When you teach, when you go to an American law school, you take a class called Constitutional Criminal Procedure. And probably the better half of that course is doing nothing but talking about motions to suppress and motions to exclude. And this is, you see this on TV all the time. This is the, they came in without a warrant, so you have to throw away the gun. This is the, you're not allowed to search my client's butthole for the bullet. This is real jurisprudence about that. That sort of thing. And so that's a motion to suppress. If you're trying to throw out physical evidence on the grounds that physical evidence was taken in violation of the Fourth Amendment's rule against search and seizure, then it is called a motion to suppress. And when you can and cannot do that is the basis of that whole class on constitutional criminal procedure. I'm kind of surprised that I have never seen in VRChat anybody actually make a motion to suppress on that basis. It seems to me probably the reason is that nobody knows anything about them, which is kind of odd because they're on TV all the time. But if a piece of physical evidence is taken, then you can end up making a motion to suppress. And then motion to suppress has a sister, the motion to exclude. Motion to exclude is for confessions, generally in a criminal case. These are, the person says, yeah, I did it, but it was at the end of a terrible, brutal interrogation. And once again, this is not really a class to be talking about when you can and cannot make a motion to exclude, but there, as a general rule, if a person is, not read their... Okay, hold on. This is the moment where I may say something that if you should ever find yourself knee-deep in trouble, that you may go, oh, Professor Pure on VRChat said that if they gave me my Miranda warnings, then that means that they can't convict me if I say I did it. Don't do that. Don't do that, okay? As you've probably heard me say many times before, do not talk to the police. Don't do it. And if you think that you can talk to the police because your lawyer will later be able to come and win a motion to exclude, that's probably not true. Not only have I never won a motion to exclude, I don't think I've ever met anyone who ever won a motion to exclude. Motions to exclude almost never work. Motions to suppress almost never work. This is so heavy that I happened to see on Reddit, r/law school, a bit of Barbary. Barbary is the company that will give you bar review, will teach you to get ready for the bar exam. They actually train people that if you don't know the answer to a question of constitutional criminal procedure, meaning who wins a motion to suppress, who wins a motion to exclude, they tell you that if you're not sure, the answer is the government wins. And that's absolutely consistent with practice. The government wins these things pretty much all the time. But so do not, if you take nothing else from this class, let it be my usual prohibition. Do not talk to the fucking police. Don't do it. But so every once in a while, somebody will talk to the police, and every once in a while, somebody will end up having a motion to exclude one. That the person was put to all kinds of torture or things like that. I mean, it's Swiss cheese, really, in the sense that it's rather difficult to tell exactly when a motion to exclude will be granted and when it won't be. But generally speaking, it's been cut down to almost nothing. This is part of something called the exclusionary rule. The exclusionary rule was born in the 1960s under something called the Warren Court, and it has gotten smaller and smaller and smaller pretty much every day until, the 2010s, when in some cases involving computers and high-tech stuff, it grew back just a little bit. But mostly the exclusionary rule has been cut down. But nevertheless, there's enough of it around that every defense attorney feels the need in a great many cases to file motions to suppress and motions to exclude. And how these work procedurally depends on the case, depends on the judge. It is the case in many places that you file your motion to suppress as pretrial, and then you come and you discuss this motion prior to trial. However, some judges in Texas actually will take motions to exclude, suppress, and turn them into trial motions. And for purposes of VRChat, I think that would be the way to do it. You would want to say, the judge would, say you're going in and you're bringing in evidence and so on. You would not make your motion to suppress, exclude at the time. I mean, if you know the way I run court, right, where I say you may discuss the physical properties of the object, but you may not discuss its story. Right, that would mean that the proper time to make a motion to suppress or exclude would be at the moment that the witness tells you how they got that knife, that syringe full of bread dough that they were using to inject people, dead bodies on the beach to turn them into bread, whatever the case may be. So there's that. And then you would end up having that evidence thrown out. If the evidence which is thrown out is so much evidence that the prosecution or the plaintiff is left with nothing, then it's said to be a dispositive motion. Dispositive in the sense that now I've won it, now they ain't got shit, now the only thing they can really do is dismiss. It may also happen that a motion to suppress or exclude can be agreed to be dispositive. So that might happen in plea negotiations in the following way. Let's say that, somebody's on trial for possession of cocaine, and they find the cocaine in the ice cream tin in the freezer. And you wish to argue that there was no valid search warrant for the ice cream tin because because the warrant just didn't specify that they could search anything small as an ice cream tin. It generally would, but let's say in this case it didn't. In that case, now you've got a question. Can the defense win the motion to suppress or not? It's not uncommon for defense attorneys to file a motion to suppress and then go to the prosecuting attorney and say, I'll tell you what, if I win this motion to suppress, then I stand a much better chance of winning the case, but I might not win it for sure. So in that case, if I win the motion to suppress, you should let my guy go at 2 months probation. But if I lose the motion to suppress, and often it would be the prosecutor who would make this offer to the defense, not the other way around. The prosecutor might say, okay, but if you lose the motion to suppress, then I, the prosecutor, will now know that you have that much less chance of winning the case, so I'll make you an offer. I'll give you, 6 months today if you take it. I'll give you 2 months if you lose it. I'll give you 2 months if you win your motion to suppress. But if you lose your motion to suppress, my offer is going to be a year. These motions to suppress, exclude are often the basis of negotiation. And lots of these motions can be the basis of negotiation because every time you win a motion, you can set that up. All right, see you off, Manny. I think we may be reaching the point of this. So that's the motion to suppress, the motion to exclude. And, you can have other motions to poll the jury at the end of the case where you can make them say the whole thing. But the field of motions is vast. And basically the idea is that a motion is something that a lawyer asks a judge to do as a sub-part of the case, and you can ask for pretty much anything. I feel like we've been going about an hour at this
Pierre,
point,
quick
I
question.
think. Yeah.
What about first of all, Captain was asking a question first.
Okay.
No, go ahead.
Fuego, do you have something?
First.
What's that? I'm gonna turn you up.
No. I was saying if he has a question, he can say it first. Mine's is going to be.
All right, Juicy, what you got?
Just a quick
All right,
one
what
about a motion for summary judgment?
Yeah. Okay. So that is something that happens in civil cases, and I said I was not going to talk about it because it's a pretrial. So for purposes of civil procedure, generally, jury trials in civil cases are not as common as they are in criminal matters. And the reason is that it is quite possible to win a civil case without ever actually going to a jury trial. And there are different ways of doing this. So the first is called a demurrer, is the classical term. And the number term is a 12b6. Or in federal court, it may be called a motion to set aside for failure to state a claim. This would be the case that if let's say, for example, that Curry should call Juicy a simp.
Huh.
And let us imagine that Juicy should have his feelings hurt by that pretty badly.
Huh.
And therefore say, I'm going to sue Curry.
Oh.
So Juicy then sues Curry for the insult. And, all right, what's the problem? Well, the problem is not that Curry didn't call Juicy that. The problem is that in the absence of other evidence, it's not illegal for Curry to do that.
Huh.
Right? That is to say, a motion to state a claim. Curry, in that case, file a motion to dismiss for failure to state a claim, also called a 12b6, also called a demurrer. Because what she would be saying in that case is, I'm not saying I did it. I'm not saying I didn't do it. But what I am saying is that even if I did do it, it's not illegal. So in that case, you can typically get a case thrown out pretty early with a 12b6 like that. So that's the first way you can get rid of civil cases. You can argue that even if everything the plaintiff says is true, they would still lose. That's called a demurrer, a 12b6, or a motion to set aside for failure to state a claim. Later on, once that happens, you then move into discovery. Now, you can file a motion for summary judgment at pretty much any point pre-trial. And although you are more likely to have your motion for summary judgment granted toward the end of discovery, ideally, assuming everything works in perfect military order, you will generally file your motion for summary judgment the day after that discovery closes. A motion for summary judgment, there are two kinds, and either the plaintiff or the defendant can file one. Only the defendant can file a no evidence summary judgment, but we don't need to go into that. Because basically, even the no evidence summary judgment is basically, it seems to be making the standard motion for summary judgment more difficult than it needs to be. Motion for summary judgment involves one party saying to the judge, and this is done in writing, it's not done orally, they will say, the other side has no chance of winning this case. There is no way that any reasonable jury could conclude that the other side wins the case. And then the other side would say, that's not true. We've got lots of evidence. And then it'd say, all right, well, show me the evidence that you've got. And so prior to the beginning of your civil lawsuit, and again, it could happen at any time, but generally you would want to do this at the close of discovery, because if you do it during discovery, then the other party might say, well, wait a minute, Judge, the motion for summary judgment, I have the right to conduct discovery. I have the right to ask the other side questions and make them answer it. And if you say that I have to be able to prove my case at the beginning, then you've denied me the right of discovery. Although in some cases, that is exactly what judges will do. But generally speaking, judges should wait until summary judgment, or should wait until the close of discovery before seriously entertaining a motion for summary judgment. And at that time, both sides will marshal their evidence. They will get everything they have together. And when running civil cases, it is perfectly common to have all the witnesses involved come and prepare affidavits. An affidavit is a sworn statement where they write down, I swear that the foregoing is true and correct. And if you lie in a sworn statement, whether it's saying I swear to tell the truth, whole truth, and nothing but the truth orally in court, or whether you write down I swear that the foregoing is true and correct, if you lie in that, you don't go to jail, you go to prison. So you collect these. Now, these affidavits, generally speaking, are not admissible evidence in trial. There may be rare circumstances where they might be, but generally speaking, these affidavits are not admissible evidence in trial. Nevertheless, lawyers will collect these. Why? Well, in a civil case, they will collect these because although they are not admissible at trial, they are admissible during motions for summary judgment. So the motion for summary judgment in many cases is the great battle that makes the whole case play out. But it's not very sexy. It's not very romantic because these motions are generally done in writing. So you're going to be sitting around your living room writing these things and arguing this whole point on paper. There may be, in fact, there often is a procedure before trial where you would argue about this. But you would not make a motion for summary judgment in court. And I did see Gray Tide in court moving for summary judgment. And once again, that was like nails on a chalkboard for me, because you don't move for summary judgment in the middle of trial. The whole point of a summary judgment is to make it so that you don't have to go to trial. So you would say there's no way the other side can win, and this has been called the ultimate discovery tool, because when you say there's no way the other side can win, the other side doesn't really know how much evidence they need to convince the judge that they do have a chance at winning. And so it's the life or death moment of the case. And typically, when faced with a motion for summary judgments, lawyers will lay all their cards on the table. They will not hold anything back, because they know that if they do, they might be dismissed while still holding valid evidence. And no lawyer wants to lose their case while still holding on to valid evidence, because then they could be looking at a malpractice claim. So generally, as a matter of strategy, lawyers will lay everything on the table while they argue their motions for summary judgment, and therefore moving against the other side for summary judgment doesn't really cost you much, except the effort that it takes to do it. And you can, even if you end up losing the motion for summary judgment, you can get a very good view of the other side's evidence. They can tell you, and you can hear their arguments. You can preview everything that they feel about why they should win the case, because you have basically put them in a position where they have to do that. But for our purposes, a motion for summary judgment really has no place because we don't have pretrial. Does that answer your question?
Yeah. I'm so sorry. One more thing too. I hope this is a quick if you can. Now there's another one I actually like that I think if you can teach 1 quick second. Motion for hostile witness.
Fucking what? I see. Move, not a motion for hostile witness. A motion to treat the witness as hostile.
Yeah, sorry. Motion to treat the witness.
Okay. Right. All right. So, a motion to treat the witness as hostile. All right. Here is the rule. You may not ask leading questions of a non-hostile witness. Okay. So if I say, what's the weather like outside? That's an open-ended question. It's non-leading. If I say, is it raining outside? That is a yes-no question. It's also non-leading. If I say, it's raining outside, isn't it? That's a leading question. A leading question is defined as a question which suggests an answer. And we do not like it when we ask witnesses leading questions if they are non-hostile, because we really feel that the lawyers should be getting out of the way. That it's the job of the lawyers to not tell the witness what to say, but to just sit back and listen to what their witnesses say. However, if the witness is hostile, then we may ask leading questions. All right, when is a witness hostile? Basically, there are 3 times. Number 1, it's cross-examination. If it's cross-examination, the witness is hostile. It's pretty much that simple. And that means you may then ask leading questions. And if you have seen me teach cross-examination, you've seen my cross-examinations, you know that you keep your questions leading, because that witness hates you and they want you to lose. And Nathan, do you remember that time that I was pretending to be an investigator in a serial killer case, and you just asked me how I was doing?
Oh, yeah. No, I was
And
actually thinking about that case today.
Yeah, that's what happens when you ask a non-leading question of a hostile witness. I said, oh, it's so bad. I haven't barely slept in 2 months because I'm just going to sleep so much better knowing that your evil client is going to be put away forever and ever and ever. And Nathan was immediately very sorry that he had asked me how I was doing. Never ask a non-leading question of a witness who hates you, because you've given that witness room to bite you, basically. You should treat a hostile witness as a hostile bulldog, hostile big dog. You don't want to put it on a long leash. You want to get your hand down there behind its head and just, no, motherfucker, you go where I say. And a proper direct examination involves the lawyer saying almost nothing, and the witness says everything and tells this long, haranguing story. Whereas a proper cross-examination, the lawyer says everything. A perfect cross-examination, the witness says the word yes 300 times, and that's it. Everything else, the lawyer is just basically speaking and demanding confirmation. And in order to run a good cross-examination, you have to have backup plans in the event that the witness doesn't do what you want. And I've talked about, good cross-examination is like a robbery. Give me what I want and no one gets hurt. If I ask you a question and it's obvious the answer is that I'm looking for is yes, say yes, and I will gain an advantage in the case. Say no, and I will gain an advantage in the case in such a way as to make you wish you were never born. That's good cross-examination. And if anybody remembers the time I was cross-examining God, when
that was a good time.
Yeah, that was fucking awesome, wasn't it? Love that. But yeah, that's good cross-examination. JFC, who was the actor playing God, said that he felt like he got stabbed about 50 times. Anyway, the rule is that if it's cross-examination, then the witness is hostile, and you may therefore lead. Another time when a witness is hostile is if the witness is the other party. Now, this would not happen in a criminal case because you can't very well call the government to the witness stand, and they're always a party. And the prosecution had damn well better not call the defendant to the witness stand, because that is, absolutely a violation of the privilege of self-incrimination. But in a civil case, the defendant may call the plaintiff to the witness stand, or the plaintiff may call the defendant to the witness stand. That can happen. And if they do, then you don't have to move. It's just automatic. That witness is hostile, and therefore you may lead. And then the third time is what you're talking about, which is when you would make a motion to have the witness held hostile. So, if the witness sits down and you say, where were you on June 4th between the hours of 4 and 5 p.m., because it's your witness. You called this witness, so you have no right to lead. But you sit down and you say, "Where were you, on June 4th between 4 and 5 p.m.?" That's not a leading question. They nevertheless say, "You motherfucker! I don't want to be here. I hate you. This whole court. This is all ridiculous. I hate you." If they really start being combative in their answers, then you, the lawyer who were not leading the witness, can then say to the judge, permission to treat the witness as hostile. And if the judge says granted, then that means, which the judge would do if they thought that the witness was being combative with you, then you would then have the right to lead. You would then have the right to ask leading questions. So permission to treat the witness as hostile is, judge, this witness is an asshole. Please allow me to punish them with leading questions. That's what permission to treat as hostile means. Does that answer your question?
Yeah, that one I kind of know. I kind of now know. But how do we catch that as, like, if someone were to be hostile towards you, but they're not trying to be like as open as it is. They're not saying like things like what you said, like, "Oh, I hate you," as it is. But they're trying to be calm and trying to be assertive about it. They don't want to get caught as it is, so making it hard for yourself. How do you know?
Yeah.
How do you make them?
No, that is difficult. So, well, first of all, I don't think you're going to see that very often, because most of the time, if you call a witness to the stand, that witness probably wants you to win the case. Because if they didn't want you to win the case, it would very often be a very bad idea to call them to the witness stand. You know, you don't want to put your life in the hands of someone who hates you.
Okay, makes sense.
And I mean, there are times when you have no choice. There are times when you have no choice. But generally speaking, if a lawyer believes that they're going to win the case only on the testimony of someone who hates them, the lawyer will generally not take that case if they have that option, or they will try to find any way around it, because it is crazy dangerous to put a witness on the stand who hates you. There are 10,000 ways that person can fuck you up. But every once in a while, you're absolutely fucked, and you've got no chance but to force somebody to testify. And you do have the right through subpoenas to force somebody to testify. But it's dangerous. And, you know, how do you... I haven't done the research, so I can't give you the exact legal, test for the subject. But, just based on what I've seen, a motion to treat a witness as hostile is typically something that happens when it is pretty obvious. I mean, you know, it's going to have to... It's up to the discretion of the judge, really, as to whether or not you can do that.
That makes sense.
Okay. Captain Fuego, do you have something?
I suppose the right way to question it is, does a police officer's written description a report? Is it considered valid in court if the person who admitted, say for example there was someone who was stabbed, and the police officer comes across a person which he strongly believes is the person who has stabbed the person, but the situation is everybody's in shock. The person is in a traumatic state. So he has forced this admission out of this crime from this person, whether they are guilty or not. I'm curious, what is the, I guess you could say, legal action
Reginald.
to court?
Reginald. Do we allow police reports in criminal cases?
No.
Absolutely not.
Absolutely not.
Hell no.
Now, here, let me explain why. If it were the... All right, this relates to something called hearsay. This is not a whole class on hearsay. I could easily teach a whole class on it. I often do.
Yep.
But it's hearsay. That does not mean... Hearsay has a lot of exceptions. And, you know, this hypothetical that you've given me is something that might be a valid exception to the hearsay rule, which is, you might have an excited utterance. We might be dealing, I mean, I don't know the facts of the case, but you might be able to convince me an excited utterance. But even if you could convince me that it's an excited utterance, the only thing that would give you would be the right for the police officer to come in and say, I swear to tell the truth, the whole truth, and nothing but the truth. And then they would talk. It doesn't make the police report admissible. If we allowed police reports to be brought directly into evidence, then no police officer would ever testify. They would just write it up, hand it to the judge, and the judge would say guilty. Incidentally, this is legal in China, and they do this shit in China. Although even my Chinese law students say that the judges are trying to stop doing that. Because they do have the sense that no, police officers do write police reports all the time, but you should not... They should not be allowed to enter their police report as evidence and testimony, for the simple reason that I cannot cross-examine a police report. It violates not only hearsay, but it violates the Confrontation Clause. The Sixth Amendment of the United States Constitution in a criminal case says that the accused shall enjoy the right to confront and cross-examine his accusers. Well, how can I cross-examine a police report? Can't do it. It's a piece of paper. I would ask it leading questions, and it wouldn't say anything because it's a piece of paper. It has no mouth.
Yeah.
So no, police reports are no, in a criminal case, police reports are no bueno. No doing that. There are very rare exceptions, like, if the defendant killed the police officer with an intent to silence him or something like that. But short of some outrageous thing like that, police reports are not admissible in criminal cases, not only for rules of evidence reasons, but for constitutional reasons. No doing that. And this is something I see VRChat players doing a lot, because there is a piece of evidence in the map called police report, And it's not that you can't do anything with a police report. Police reports are extremely valuable. You use them to construct your cross-examination. Because when you are going to ask these leading questions, you have to know what to ask. Well, the way you do that is you take your police report. And that's how you know what the police officer said. And if the police officer testifies to something that is not in the police report, then what you do is you say, "You're a good cop, right?" And they say, "Yes." And you say, "And they taught you how to write a police report in the academy, right?" And they say, "Yes." And they say, "And they taught you that you should write down everything that's important, yes?" "Yes." And then you testified that you found the gun in the refrigerator, right? "Yes." And you happen to know that it doesn't say that in the police report. Then you would say, "All right, I have your police report here. Is this your police report?" And it would say, "Yes." And then if they should at that point say they don't remember, then maybe you can bring it in as evidence at that point. But they wouldn't do that.
Yeah.
So then you would say, "Yes, this is it." And then you take your baby blue highlighter. And you say, "I have a baby blue highlighter here. Please highlight in the police report where it says you found the gun in the fridge." And then they're going to stare at it for a good 5 minutes and then look up like they wish they were never born and say, "It's not in there." Or if they try to say that they didn't do something that is in the police report, then you're going to take your pretty pink highlighter and say, "This is your police report, right?" Say, "Yes." And you're going to take that pretty pink highlighter yourself and highlight the thing and say, "Please read the section." It says, "We found the gun in the refrigerator, and when we did, the defendant's wife said that she did it, not the defendant." And then you take that and you show it around, whatever. So you can use the police report to make a police officer stick to their story, but it's not admissible on its own. Okay? Does that answer your question?
Yeah. I certainly ask it in the sense of, like, when our police officers antagonistic to the witness, say if they falsely accuse somebody and how that proceeds. So yeah, that is a pretty good way to
all
go
accusations that police officers make are false. Police officers are antagonistic to everyone. I don't see the.
Yeah, that's what I meant, and that's what I want.
I mean, like, yeah, you don't get to say, as I was saying earlier about striking witnesses' testimony. You don't get to say this witness is a liar, therefore they're not allowed to testify. Everybody gets to testify. Even liars, even cops who have been found to have been liars. So, for example, it has happened. I've been in a situation where a police officer had been convicted of aggravated perjury, of lying under oath. And, in a reasonably competent system, that police officer would probably be fired, because you don't actually want to have a police officer who's a fucking felon coming and testifying. But they did it. And in that case, under the Brady rule, if the prosecuting attorney has evidence which tends to show that the defendant did not do it, then they have to tell the defense lawyer. And that includes the fact that one of their witnesses is an aggravated perjurer. And so that the defense attorney can then cross-examine the person, so they'll then give a copy of that. But then all the defense attorney can do with that information is then say to the police officer on the witness stand on cross-examination, "On such and such day, you were convicted of the crime of aggravated perjury, weren't you?" And they'll say, "Yes. But your client's a damn dirty sumbitch, so you find him guilty anyway." Does that answer your question?
Yeah, fair enough.
Cool. Any other questions?
Nope.
Cool.
I have a question.
Oh.
Yes, Raccoon Queen.
So I heard that in some cases where you believe the defendant's like guilty or you have self-interest in
The prosecution
case,
always believes the defendant is guilty. Yes, continue.
and then if that's the case, if you have personal self-interest in the case, you normally, is what I hear, you're supposed to remove yourself from the case. But say for instance,
Are you talking about a lawyer or a judge?
The lawyer.
Yeah, it's called a conflict of interest. So there's a
Conflict
motion
of
there.
interest.
Yeah, it's called a motion to withdraw. And I talked about this last time I had a law class on attorney ethics. If the attorney has an interest in the case, or what's more common is that an attorney is representing someone who has an interest in a case. So lawyers will keep what are called conflicts databases, where every time they encounter a person who comes to them for legal advice, they stick their name in a database. And every time they're working on a case and they find the name of somebody is relevant to the case, they stick that name in the database. And every once in a while, they stick a name in and the thing goes, beep, conflict of interest. And now they have to make some ethical decisions. Well, you may be working on a case and you may find that you have grounds for withdrawal. Because once an attorney has taken a case, as long as that case is currently before a judge, that lawyer does not have the right to just quit. You need the judge's sign-off in order to quit. There are many reasons why you would do this. The most common reason is, I ain't been paid. But it could also be for a conflict of interest. It could also be because the defendant is misusing your services in such a way as to make you in danger of committing crimes. Another way would be that the defendant, or that your client, not the defendant, that your client is demanding that you make certain legal arguments that you find absolutely, although legal, absolutely outrageous. So, there might be, somebody might want to run a gay panic defense, where they say, I curb stomped that dude because he's gay, and it just seemed to me like the thing to do. And because I was having a panic attack over this. This is called the gay panic defense. I was worried that gay person was coming on to me, and so obviously, in order to protect my own masculine identity, the only thing I could do was to murder him. The gay panic defense doesn't usually work. But there are cases where it has been made, and in some states, the gay panic defense has actually been outlawed. I think that as horrible as a defense as that is, I generally hesitate to say that any defense should be made illegal. But nevertheless, some states have made the gay panic defense illegal, but most of them have not, last I checked. So if somebody wants to make, say, a gay panic defense, or somebody wants to just, say, something that just the lawyer just couldn't dream of themselves saying in public, I killed him because he was gay, or she was asking for it, or or I did what I did because whatever. Some people just make these arguments in court that makes you go, oh my God, I just feel like I need to take a shower after talking to you. If that's the case, the lawyer may move to withdraw. But whatever the reason, if the lawyer is withdrawing, you need the judge's permission. And so what you do is you file, it's a written motion, it's pre-trial generally, and then you give your 3 days notice and you say, I move to withdraw. And in that case, you actually have to serve your own client because of, obviously, they're going to lose out. They're going to lose a lawyer over the deal. And then, of course, not only can a lawyer move to withdraw, but every once in a while, a client in a criminal case might move to have their court-appointed lawyer removed from the case. This is not usually granted. In California, they call it a Marsden motion. But then, to say that the lawyer is fucking up, then, they should be removed from the case. But yeah, that's a motion to withdraw. And these are not always granted. Sometimes the judge says, we have been working on this case for the last year. We've got a speedy trial problems coming up. So for example, if it's a criminal case and it's taken too long, somebody might move for dismissal for reasons of speedy trial. And the judge says, in order to prevent the next person from moving to speedy trial, we just got to take this case to trial. And Madam Defense Attorney, Mr. Defense Attorney, I don't care that you have a conflict of interest. I don't care that this case makes you sick to your stomach. I don't care that you haven't been paid. You work the damn case. I've had that happen to me. But generally speaking, these are given pretty freely early on in the case. And there's a practice that I don't like. I never did it. It makes me sick to my stomach. But what most lawyers will do is they'll take a case and they'll say, I'll make some court appearances for you as long as you're paying me. But if you want to go to trial, it's going to cost you more money. And that it's going to, if you don't get paid, then I'm not going to go to, if you don't pay me, I'm not going to take you to trial. I think that's icky. That seems like a sleazy thing to do, but most private defense attorneys do that. And then, all right, well, you may tell them I'm going to withdraw if you don't pay me. And generally speaking, a consistent, not just I missed one payment, but there's been a consistent failure. And the general rule is they miss 3 payments. Then at that point, a judge will, in most cases, grant a motion to withdraw, which sucks because then, the attorney's been paid all this money and they've probably found up reasons to justify having burned through their retainer account and however long it's been. And, now you've lost all this money and you're up to your ass in alligators because you've got your criminal charges and you just lost your lawyer. That's a lousy thing to do. So my rule was that, if I took a case, I was going to finish the case, even if I lost money on it. And I lost a lot of money. I was a good lawyer. I was a very, very bad businessman. Does that answer your question?
Kind of. It was more of a sense like, if you're fully aware that you're like say for example, this guy, you're fully aware that he murdered this person. He's guilty. There's no denying it, and you represented him. And
who gives a shit?
Yeah.
I mean, he's guilty.
You,
so
you're
what?
Fully aware of this.
So
is it like, would there be any consequences because of that if they found out like you knew he was guilty because of that? If you as his lawyer.
Absolutely, positively not.
Or, okay.
No. In fact, it's written into the rules. I mean, just because your client's guilty doesn't mean you're not going to represent them. In fact, it's written into the rules of evidence that, or not the rules, to the rules of attorney conduct, that although a frivolous argument. A lawyer should not make frivolous arguments. A criminal defense attorney may nevertheless demand that every element of a case be proven. Even if the evidence is overwhelming, you can still do that. The only issue that comes up, if your client should tell you that they are guilty. And first of all, let me tell you that most of your clients do not tell you that they are guilty. But if in the event that your client should tell you that they are guilty, then the one thing you may not do is you may not you may not suborn perjury. You may not say, you've got the classic case about this is, let's say there's a bank robbery and that your client, the defense attorney is sitting at counsel table and the bank teller gets up and the bank teller comes up to testify to say, yeah, I saw the defendant, he robbed me. And the defendant should notice that the witness, the bank teller, is wearing glasses. And the defendant should lean in and whisper to the ear of the defense attorney, yeah, I robbed her, but she wasn't wearing glasses at the time. There's no fucking way she recognized me. Then in that case, it is totally okay for that lawyer to say, you wear glasses, don't you? Yes, I do. And you were not wearing them at the time, were you? Even though the defense attorney knew, even though the defense attorney's source of information for the fact this person was not wearing glasses is the fact that your client is indeed guilty, doesn't mean you can't ask that question on cross. That's totally okay. Furthermore, the one thing you cannot do is you cannot allow your client to lie in response to a direct question. So the one time where that would come up is that if a defendant were to say to a defense attorney, I did it, and not only did I do it, but I want to testify and say that I didn't do it. I want to come and say, I swear to tell the truth, the whole truth, and nothing but the truth. I didn't do it. In that case, the defense attorney will generally, first of all, advise the person, don't do that. And generally, if they're facing a minor crime, like a misdemeanor, then that makes sense, because who would commit felony perjury in order to get out of a misdemeanor? That would be stupid. But felony perjury, although a serious felony, is not as serious as, say, murder. You're not going to get the death penalty for it. And, therefore, you might have a murder case, and somebody will say, yeah, I did it, and yeah, I want to take the stand and say that I didn't do it. And, you as a defense attorney may get this information. Well, at that point, generally speaking, the wisdom says, number one, you should try to advise them not to do it. But if they persist and say, no, this is what I want to do, well, that person has a constitutional right to tell any story that they want, and you have no right to get in the way. So in that case, the next step is that a defense attorney will generally file a motion to withdraw. And they'll say, I don't want to represent this situation because doing so could involve me. And generally, they will not write down in the motion because my client told me he did it. I mean, that would be awful. You don't do that. No, what you do is you say, I have an ethical reason for which I need a motion to withdraw. And, if it's a famous case, then the press will see that, and they will very often assume that means that the defendant said they did it. It's not the only reason for seeking a withdrawal, but it is one reason for seeking a withdrawal. So you would then wish to speak with the judge, and maybe you need to go back in chambers off the record to explain to the judge, yeah, he told me he did it. And if this happens, the judge is not going to go, oh my God. The judge is going to go, yeah, all right, another one of those, sure thing, because they see this shit all the time. And then they're going to go, okay, well, your motion is granted typically. And so if the motion to withdraw is granted, then they're gone. But now this person needs a new lawyer. So the judge is then going to appoint another lawyer to represent that person. All right, well, that new lawyer is going to need time to prepare. So that means, hopefully that new lawyer, hopefully by this point the defendant will have figured out, if I tell my defense attorney that I did it and that I want to testify and say that I didn't, that defense attorney will withdraw, and therefore I will not get to have a good lawyer. However, it may be that you may be dealing with a criminal defendant who thinks that that's a fantastic thing because they're going down, and if it means that they get to go another month while the new attorney gets set up, they'll do anything for that other month. Criminal defendants are desperate people. They will pull fire alarms. They will insult counsel. They will do anything in order to just get that one more month continuance so they can use that to see the sunshine again. So in that case, they may tell their new lawyer, and the new lawyer may then move to withdraw. Well, they're not going to let this go on indefinitely. Once it's happened once, maybe once it's happened twice, the judge is going to look at the defense attorney and say, tough shit. I'm not letting you go. You now have to try the case. And when that happens, now if the defense attorney puts the person on the stand and says, did you do it? And they say no, that defense attorney is just suborned perjury. Now that not only is the defendant on the hook for perjury, now the defense attorney is on the hook for perjury. Shit. So what the defense attorney will do to avoid that outcome is they will just put the witness on the stand and they will say, you have a constitutional right to make a statement to this jury. Do you understand that? And they'll say, yes, I do. And you say, what is that statement? And then they will say, I didn't do it. I'm a complete bystander, whatever. They'll tell their whole story. And the defense attorney will say, thank you very much. I'm done. In this way, the defense attorney doesn't actually end up suborning perjury, but they also do respect the constitutional right of the defendant to make any statement that they want to the jury, and the defense keep it to themselves, the defendant's admissions about that. Does that answer your question?
Yes, it does.
Cool. Any other questions?
I do have one more if I can ask.
Yeah, go ahead, Raccoon.
Beginning of the lecture, you were talking about how you have to send paperwork back and forth between you and the other party to make sure you have all the right documents before the trial and things like that. Is there a way for you to kind of forge the other side without them actually receiving the documents they need? Or that's impossible to do, if that makes sense.
Is there a way to commit forgery? You might go to prison. You'd probably get caught.
Yeah. But if you don't get caught, let's say, for instance, it goes to trial and they have evidence like, hey, I have paperwork saying I said this to the office over there. They have all this kind of things, but yet they don't have
Right, well, understand that if you were to try... there are some documents that if you were to forge them, nobody would look too closely at them. But these are documents which, if you're going to forge notice to somebody, that somebody is going to be highly, highly motivated to prove that you forged notice. because that's their ass. They're gonna do everything they can, and it's gonna be pretty difficult for you to prove that they got it, because they, I mean, like, could it happen? Sure. I mean, theoretically anything could be forged, but they are gonna. It's gonna be, that would be a rather difficult forgery to make. Depending on how it's done, because you're generally going to want to add to that some means of showing that you gave the other sides the documents. So in the case of court case initiating documents, which is not what I talked about, is motions, but service of process servers will generally wear body cameras, and they will show themselves handing the documents to the person. Furthermore, even in the case of that, I mean, your fax machine is going to give you a receipt, or your modern lawyers will generally do this through the case e-filing system. And the e-filing systems, these were, this is the court's record. So if you're going to be forging anything in there, and they're going to say that's not in there, I mean, you could maybe forge a PDF of a print off of that, but that wouldn't get you very far, because the court would just immediately go, well, let me check my records. They would check their records and be like, no, your PDF is bullshit. Never mind, you lose. But, I mean, you're not going to be forging the court's record unless you're going to be, hacking court databases, in which case, you're probably going to prison for a long time for that. I do not advise it. Does that answer your question?
Yes,
Yeah.
it does.
Cool. Any other questions?
Do you accept friend requests?
Yes, I do.
I was saying that's an
Raccoon, you
obvious
want one?
question.
New friends are amazing.
Especially when your friend
Raccoon,
is
is
an
any friend
actual
request?
lawyer.
Cool. Awesome. All right. Boop. All right. New friends. Yeah. Fantastic. Okay. And how about you, Vesta Crown Guard? There you go. Yeah, it would
Hello.
be just fine. Sure thing. Hi there, Vesta Crown Guard. You've been sent here. I haven't actually
Can't
turned
wave,
on your
but I
Abby yet.
will later. Hello.
Awesome.
I believe we're in the clear.
Awesome. Okay, hold on. Yeah, I think Mr. Crown, I think having a great score for me. We'll see. No, it's okay. No big deal. Okay.